Welcome to the Computer Security Seminar. Our speaker today is Rick Aldrich of Booz Allen Hamilton, and he will talk about what's new in cyber law and overview of recent legal developments. Rick.
Thank you very much. I come to you today from Washington, D.C. That's where I primarily work. And my primary client is the Department of Defense Chief Information Officer. So some of the cases that I'll be presenting to you today will have a military flavor, but all of them have more general application to virtually any federal agency or to any state agency or even a lot of times to corporate entities. What I'd like to do is run this as informally as possible, so if you have any questions at any point, just raise your hand. I'll also be asking you some questions, so I'd like to see if we can get some interactivity that way too. Although I am an attorney, this presentation is not legal advice, and I have the full disclaimer down there in the fine print. So if there is anything that you want to take action on, you should actually seek an attorney for the specific facts and circumstances of that case. This is just general legal principles that will help you become more aware. Why this briefing? Basically, I'd like to update you on some of the cutting-edge legal developments in cyberspace because this is a very immature area, so the law tends to change quite rapidly, especially in response to changes in technology. And a lot of the things do impact information security and information assurance, so I wanted to highlight some of those for you today. The first thing I wanted to do is talk about on the international scene, what do we have? And the primary thing we have on the international scene is the Cybercrime Convention. And as you can see by the slide, that was ratified in 2004 by the necessary 5 parties. The United States signed it at that time, but didn't actually ratify it until 2006. And it took effect for the United States in 2007. As you can see there, 26 nations have ratified it so far. But if you look at the list, it's kind of a mixed bag. A lot of small countries, some major countries that you might expect to be in there have not ratified it yet. So we're still looking for more things there. There's a couple issues that are identified down there that have caused some people some consternation about this treaty. Overall, most people think it's good, but a couple issues down there. One of them is lack of dual criminality. Does anyone know what dual criminality means, what that concept means? Okay, does anyone remember when we had the I love you virus that spread pretty much around the world? And where did they eventually track the person who wrote that code to? The Philippines, correct. Now, did we ever prosecute that individual? No. And why didn't we? The reason is because it wasn't a crime in the Philippines. So even though we have an extradition treaty with the Philippines, unless it's a felony both in the United States and in the Philippines isn't required to extradite the individual. Now, if he were to travel to, say, like Disneyland to celebrate this fact, then we could seize him while he's here, because then we don't have to worry about the extradition treaty. But so one of the issues here is that there's a lack of dual criminality for mutual legal assistance. And what that means is that countries could ask us to assist them on issues that weren't crimes in our country. And some people have a difficulty with that because some people have very strict laws with regard to what you can publish on the internet, which would violate our First Amendment. When I talk to people from the Department of Justice, they say that's not how we are interpreting this provision, and so it's not really an issue they don't believe. The other one would require the divulgence of a decryption key. And there's some somewhat vague language in the treaty that indicates there may be a necessity for law enforcement to assist in obtaining a decryption key. And in our country, that can be somewhat difficult because of our Fifth Amendment, right against self-incrimination. So those are just a couple of issues that were raised. And, but overall, as I indicated, that's a very helpful treaty, especially the 24/7 points of contact. This allows any party to the treaty, and actually people who are party to this separate side treaty, to also use experts in the countries to help track down the perpetrators of cyber crimes. You can actually call up and ask them, okay, how do we get this data from you immediately, or how can you stop this, or how can you preserve this evidence? The next thing I'd like to turn to is the NATO treaty, the North Atlantic Treaty Organization's treaty. And the reason I bring this is some of you may be aware that Estonia and Georgia suffered some pretty significant cyber attacks on their infrastructure. Some of them weren't able to bank for a few days. They weren't able to use the internet. They weren't able to do a lot of things that they do by internet. And so some people asked, what was the implication of this? Does this constitute an attack against Estonia such that they could ask NATO to invoke the defense of all provision. And at the time, NATO said no, because NATO qualified it as a cyber riot. And a cyber riot doesn't count as an attack against a member. That's more like a civil disturbance. So they were able to finesse the issue that way. But I think it has caused a lot of people to look into the future and say, okay, how are we going to be able to deal with this in future situations? Because it looks increasingly like countries may use a cyber attack to either magnify or complement a more traditional kinetic attack. Okay, now within the United States, it's important to know what role you're playing to determine how the law applies to you. And because the way Congress has written our laws, there's relatively rigid lanes in four main areas. One is if you're a system provider, and that would be like if you're an ISP or you're a system administrator for a university, things like that. Those are all in the category of system provider. There's a certain body of law that applies to them that allows them to do things that other people can't. Even without separate consent or anything else. They're allowed to do certain things in that role that other people can't. Another role is law enforcement. Another role is counterintelligence. And a fourth role is when we're actually involved in war, the war fighters. What can they do? So those are the four main areas. And we'll touch on those a little bit as we go through some of the case discussions that I have later on. Now, if you look at this spectrum, I've kind of tried to place on there where different types of activities would go. So you have ping on the far left, which is basically you just trying to determine whether a port is open. Some have made it akin to a knock on the door, where you're just trying to say, is anyone home? Now, that might, if you were doing a broad ping, that might be a little bit more like checking each window, checking the fire escape, etc. But most courts have held that a ping is not illegal. Now, it could become illegal, just like knocking on the door could become illegal. If you continue to knock on your neighbor's door and then run away and then knock again and run away and knock again, that's generally some type of criminal mischief in most jurisdictions. And likewise, if you do a ping of death, such that you ping a computer so many times that it can no longer function or you seriously degrade its ability to function, that would constitute a crime. But basically on the far left are those things which generally won't constitute a crime, and on the far right, the far more serious things which could actually constitute cyber war. And the things in the middle, and the reason I have it just phased in, is that there's no strict cutoff points. What could constitute cyber terrorism could also constitute cyber crime, and it may even be constitute cyber espionage. Although certain times it's going to depend on who the sponsor is. So generally, in the legal sense, a nation state has to be the sponsor of cyber war. So when Chinese individuals were attacking the United States and United States hackers were attacking back at China over a P3 incident that was some years back, a Navy spy plane, some people in the press said there's a cyber war going on. But it wouldn't technically be a cyber war unless the nations were behind it, unless they were sponsoring it. And it wasn't so clear that that was the case. And that was also the case with the Estonia issue. A lot of people weren't able to attribute the source of that specifically to any one nation. Several people theorized that Russia was behind it, but other people said, no, it looks like Russia is just acquiescing in it, that there may be a whole lot of subordinate actors doing it. And that's part of the problem in this whole area, is actually being able to attribute the source. Cyber terrorism, you're generally looking there at a sponsor who is trying to do something for political or religious reasons. So they're trying to make a big impact, and oftentimes they will commit cyber crimes in order to do that. And cyber espionage, we're also looking at a nation-state sponsor generally there. Now, the law is constantly changing, as I told you, and the most recent change to the Computer Fraud and Abuse Act occurred last year. Under the, strangely enough, the former Vice President Protection Act is where it came under, because it happened to encompass some things about that too. But a couple of things, and I'm not going to go through all of these, but a couple of things, it for the first time made it a crime to conspire to commit a computer crime. Prior to that, you could conspire to commit, and there was no separate crime for that. So now there is. And then, most importantly, perhaps, it eliminated the requirement that damage to a victim's computer exceed $5,000 in certain types of offenses, because in some cases that was a little bit difficult to prove. So it reduced that, that necessity. Oops. Okay, so now I'm going to go into some cases, some actual cases, and I'm going to give you the facts, and then I want you to play the judge. So listen carefully to the facts, and then I want you to tell me how you think the court would rule. In this particular case, there were two Russians, Vasily Gorshkov and Alexei Ivanov, And what they did is they would break into U.S. corporations, steal credit card numbers, and then contact the corporation and say, I have some credit card numbers of your customers, and unless you hire me as a computer consultant at a certain wage per year, then I'm going to publish this on the internet, and your stock's going to go plummeting down because everyone will know that you can't even keep your customer data secure. So a lot of companies, in response to this, they actually paid the money. But one company said, we're not paying. And so they contacted the FBI. So the FBI set out to basically a sting operation. First, they called Russian authorities and said, would you help get these guys to be extradited to our country so that we can prosecute them? And Russia said no. So then they said, okay, fine, we'll do it ourselves. So what they did is they set up a corporation called the Invited Corporation to invite these two individuals to come to our country. They set it up in Seattle. They sent them messages saying, we heard that you have exceptional skills as a computer security consultant, and we're wondering if you'd be willing to work for our company. If so, would you please fly to Seattle and interview with us? So they flew to Seattle. When they got there, they said, well, before we hire you, we'd like you to demonstrate your computer skills. Would you please use this Invited laptop to show us how you can hack into people? So they said, well, we left all of our tools in Russia. And they said, that's all right. Go ahead. You can get them, and download them to this computer and use them. So they used the Invited Corporation computer, which had a keylogger on it, to sign into their site in Russia, download their tools, and then show that they had these good hacking skills. Well, the FBI had sealed indictments against them, so as soon as they had their user ID and password, they were seized and taken away. Then the FBI went back into their place in Russia and downloaded several gigabits of data to use against them in their trial. Now, after they downloaded it, they secured it. Then they went to a federal court judge and said, we would like a search warrant to search this data. They used that search warrant. They searched the data, and they used that data to prosecute them. At trial, Gorshkov said, wait a minute, Fourth Amendment, you got the search warrant after you already got all the data, so therefore you should not be able to use the data against me. How many of you think that this was a Fourth Amendment violation? Raise your hand. How many think it was not? Okay. In this case, the court said it was not. The reason they said it was not is, who would you get a search warrant for to search computers in Russia? Okay, we have no judges that have jurisdiction over Russia, so there's no way you could get a search warrant. So the court said the Fourth Amendment applies to people within the United States. It does not apply to people outside the United States. Now, in rare situations, it could. If a U.S. military member is abroad, for instance, and U.S. personnel are trying to do something to him, it still would. But generally, it doesn't apply outside the United States. So the court said, actually, we think what was done in this case was the best thing. They pulled it into the United States, but then sought a search warrant before they used it. Now, I will say there's a little bit of a problem here, and that is, a keylogger does what? It records every keystroke. If you're communicating overseas, what you're doing then is not just pulling data off of a computer, you're actually recording a communication. In the United States, that requires a higher order called the Title III order, not just a regular search warrant. They didn't have a Title III order in this case. And so some might ask, well, wait a minute, how did they do the wire intercept then? So I asked some of my friends in Department of Justice, I said, how'd they do this? And they said, oh, well, they had a consent form that they had to click through on the computer before they could use it. And I said, oh, okay. So they clicked through that consent form, and he said, well, actually, the undercover agents got a little antsy, so they went and clicked through it before and then gave him the computer. Okay, now does that create any problems? Okay, now the agents consented to the interception, but they haven't. Interestingly, though, neither of them raised the interception issue, so it never became an issue at court. But it does create some issues potentially for future cases. Okay, now this is an interesting case. For the longest time, the Department of Defense had a banner that whenever you go down to any Department of Defense system, you click through it and it says, I consent to being monitored, I know you can search everything, blah, 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 blah. This is a government computer. And I understand that you have something similar, although it may not be implemented in a banner, it may be implemented in a user agreement that you sign at the beginning of the semester or something like that. So we had one of those, and but while that was in effect, a Lance Corporal Long, Lance Corporal is a very junior rank in the Marine Corps, She found out that she might be called to give a drug urinalysis sample. In the military, you can be asked at a random basis to give a drug urinalysis sample because they want to make sure that military personnel are not using drugs. She found out that that might be happening, and she got very nervous. So she got onto her Marine Corps computer using the Navy Marine Corps intranet and sent letters or emails to her friends saying, first of all, does anyone know how good this drug test is? Could it actually detect my use? And secondly, if it can, does anyone know any good masking agents that could mask it for this purpose? Well, as soon as the investigators found out that she had sent those emails, those are obviously very incriminating. So they went to the system administrator and said, would you please retrieve these emails for Lance Corporal Long over these dates? They did. They were used at her trial. At trial, she said, I object. You know, I had an expectation of privacy in what I use on the computer. Now, the military judge said no. He said, you click through the banner, you have no expectation of privacy, so all of it comes in. She appealed, and at the Navy Court of Criminal Appeals, they said, no, we believe that she did have an expectation of privacy in this case, and so therefore we're going to overturn the fine, or excuse me, they were going to overturn it, but they said there was so much evidence anyway, she still is guilty. So then it got appealed by both the government, who said, no, we shouldn't have had to do that. And then secondly, she also appealed saying, no, if they did it wrong, then I should be free. So on appeal, the issue is, does a military member using a military computer over a military network have a reasonable expectation of privacy in that use? How many of you think yes? How many think no? Okay, and that's what we all thought, and you would all be wrong. The United States Court of Appeals for the Armed Forces, which is the highest military court, one step below the Supreme Court, said that there was an expectation of privacy based on three things. One, she was told to come up with her own password, and she was told not to tell anyone that. And she thought, if I have my own password and no, I can't tell anyone, then obviously I have an expectation of privacy and anything behind that password. The government argued, no, the system administrator can go to right around that password. He can change the password. It doesn't matter. Everyone's given a password. It doesn't matter. The court said, no, we think it's important nonetheless. Now, this was the part that killed the government, however. When the government brought her emails in at trial, they asked the system administrator, are these the emails that you retrieved for us? And he said, yes. On cross-examination, the defense counsel said, do you always read everyone's email? And he said, oh, no, because I think they're private. Okay, so now you have a government witness saying he thinks they're private. Now that's a big stake in the heart there for us. And then the final one was they said, we also think the banner was weak. We think the banner was written in such a way that it only gives a very limited reduction in the expectation of privacy. So based on that last one, what we decided to do is retrain all of our system administrators so they wouldn't do that second error. The passwords we actually address in the banner now. When you click through the banner on the DoD system now, it says you will be given passwords, encryption keys, and other things, and these have no benefit to you. They are only to protect government communications from others, not to protect your personal communications. So we did a lot to modify the banner. The federal agencies who followed us on our earlier banner are also changing their banner to match this. We are still having some issues, however, with attorney-client privilege, because within the military we have attorneys who advise defendants. We also have clergymen who discuss things with penitents, and we also have psychotherapists who discuss things with their patients. And all three of those have a privilege, and all those privileges require some type of expectation of privacy. So they were complaining, saying, whoa, wait a minute, now that you've made it really clear I have no expectation of privacy, how do you expect me to communicate with my clients? And so we had to put a little extra thing in the banner to accommodate that, and that has made it a little bit more confusing, but hopefully it'll all stand up. Okay, so just a few months after, probably about 18 months after that case came down, and before we had a chance to change the DoD banner, this case came down. A reservist major who was filling a desk for a deployed officer over in Iraq, he was staying stateside while the other officer went abroad. He apparently was bored at his desk, so he started soliciting sex with minors. And he did this in such a way that it obtained some notice by the local law enforcement authorities, not the military, but the local. So when he went to meet 14-year-old Kristen, who was actually an undercover cop, they arrested him. And then they called the military base and said, hey, we just thought you ought to know, we have one of your majors in jail down here for trying to proposition a 14-year-old over the internet. So the military was very concerned about this, and the commander said, okay, well, I want his office searched, and I want his computer searched to find out what the heck he's been doing while he's been at this desk. So they did, and they found additional incriminating evidence against him. So he moves to suppress the search of his office and the search of his computer, claiming he had an expectation of privacy. Now again, this came down after the Long case came down, which I just told you about, and before we changed the banner. So there are two issues. Does a military member have a reasonable expectation of privacy in his office space? How many think yes? His door was locked. How many? His office is on the military installation in a military building. How many think yes? How many think no? Okay. And then the second question is, does a military member have a reasonable expectation of privacy in proxy files stored in his computer? Now, this is slightly different because what they claimed is that the proxy files, which are generated automatically by Windows, indicated the types of programs he was using and what times he used them, etc., but that they were generated by the computer, and therefore he would have no expectation of privacy. Now, do you think that's a distinction that the court should recognize? How many think it is? Okay, and how many think it is not? And some people aren't playing anymore. Okay. Okay, so the Air Force Court of Criminal Appeals held that there is no expectation of privacy in the, that there was no expectation of privacy in the log files. So they could seize those because most people wouldn't even know that they're there. And then they said because of that, it's distinguishable from long. But it went to the next level of appeal, and at that next court, they did something very strange. They said, no, we're not going to make the distinction between log files and other, because at the oral argument for this case, the investigators admitted they didn't just seize log files, they seized other files from his computer anyway. But they said, no, he still had no expectation of privacy. And now let's look at their rationale. First, they said the banner put him on notice. He says, wait a minute, long case, you said the banner wasn't good enough. They said, oh, no, it's fine. Then they said, well, you didn't even testify as to what your subjective expectation of privacy was, because you're supposed to say, well, I thought it was private. Well, it turns out Long didn't either. She never testified in her case. So he's like, well, wait a minute. Then he says, well, I was issued a password. That worked for Long. And they said, oh, no, passwords are not significant. And then finally, what seemed to turn it was the commander said, well, I could have accessed his computer and seen everything on there anyway, so how could he have had an expectation of privacy? Now, interestingly, this was incorrect because the individual actually had an encryption key, a special CAC card, common access card, which encrypts his files. And so although the commander could have got on the computer, he could not have gotten into any of his files. So strangely enough, the only thing that really was the difference between Long seems to be erroneously reported. So this is kind of a strange case. Okay, so the next case we have is actually a commercial case, Quan versus Arch Wireless. And this actually involved a police department. The police department had an email policy that says everyone should realize that there's no expectation of privacy when you send emails as part of your official police duties. And subsequently, they got these little text machines. Now, hardly anyone uses those because we have far more sophisticated PDAs now. But they had little devices. They could just send text messages. That's all they could do. And so they purchased these text message devices for the police force. And they purchased a contract which would allow them to send up to 25,000 characters per month. Well, it turns out a lot of the policemen were sending a lot more than 25,000 characters. And so the individual who was responsible for collecting the money to pay for this, he said, look, if you do go over 25,000, you're either going to have to pay that overage because we didn't pay for it as a police department, or you're going to have to explain to me why you're going over, and you're going to have to show me all your emails. And he says, but if you don't, if you're just willing to pay, I won't look further. So Quan just paid every month. He paid quite a bit. And then finally, a lot of other people were paying. So the chief of police says, wait a minute, this isn't fair. If they're doing official police duty, they should not have to pay extra just because they send a lot more characters. So I want everyone's log files to be reviewed to see what text they're sending. And if it's really all government official, police business official, then I'm going to up the limit. Well, when they did this, they found out that Quan had a bunch of personal sexual messages in his thing. And so they took action against him. And he says, whoa, wait a minute, I had an expectation of privacy. Because they told me as long as I paid, they wouldn't check my emails. Now, the government says, well, no, it was clear in the policy that anyone who sent these types of text messages had none. So how many of you think that he does have an expectation of privacy? How many think he does not? Okay, it's pretty evenly split here. What they ruled is that he does not. That he does. I'm sorry, that he does. They said even though the policy said that he does not, the fact that someone implemented it in a way that gave it back is significant. Now, the problem with this case is that it puts every agency or corporation into a bind. Because as you know, we changed our whole banner. We did all this training and everything else in the Department of Defense to make sure we had a good banner. But what this case seems to say is that some really low-level person somewhere in the chain of command could say, well, don't worry. In my unit, I'm never going to check any of your email. And he could effectively trump our policy, even though he has no authority to change it. Because this court says that if they do by action something contrary to their policy, that can effectively change it. Now, the other issue that got raised is, does the chief's intent matter? And the lower court said, well, yes, it does. Because since he was just trying to do a good thing, he was trying to save people money, then that's a significant thing, and so then it doesn't become a problem. But the higher court said, no, it doesn't matter at all. Regardless of what his intent was, if the lower level employee effectively changed the policy, that's effective. Okay, now here's an interesting case. An individual views child porn on the internet while he's on a business trip. Then he goes to Canada. Well, when he arrives in Canada, they check his record and they see that he has some minor convictions in his past. And they're related to sex, so they ask to search his computer. They search his computer and they find this child porn on there. And they ask him about it and he says, well, I didn't download any child porn. I just looked at it. I never saved it. Because he says, I wanted to make sure I didn't get in trouble with the law that says you're not allowed to save child porn. I just looked at it. Now, of course, when you look at it on the computer, it saves an image in your cache. That's how the computer can display it to you. So even though he didn't save it, apparently he didn't realize an image was still saved on his computer. So they said, okay, you're not coming into Canada. So they called U.S. Border Patrol and said, hey, we're sending him back to you because we're not letting him into Canada. We're going to fly him to the Seattle Border Inspection Station tomorrow, or Seattle Airport, actually, and you guys take care of him, whatever you want to do. So when he arrives in Seattle, they seize his computer, and they search it, and they find these same images. They prosecute him. There's two issues here. One, is the search legal? The customs agents who seized the computer never got a search warrant, or search authorization, or anything else. They just started looking through. So how many think that is a legal search? How many think it's an illegal search? Okay. And then the second issue, well, let's just do that one first because that's a big one. The court held it was legal, and they said under the border exception to the Fourth Amendment. In other words, when you're near the border, the government has a lot more authority to search without a warrant. Now, how far does that border go? Is Seattle on the border? No. So why did they get to do it in Seattle? What's the issue there? Okay, right. Could I do it in Indianapolis? Could I say that I'm going to do a border search in Indianapolis? Yeah. Yes. Why? Right. And as long as you came in on an international flight and this was your first stopping point, it's also your border. Okay? So the court held in this case it was a border search, even though it did not occur at the border. It did occur at an international airport, which was his first stop in this country. So therefore, no search authorization necessary. Question?
I'm just wondering whether he could have made the case, since he hadn't been admitted to Canada, that he hadn't left the U.S.
Yeah, the unfortunate thing is physically he had. So he did. He theoretically didn't cross the border in a way because they rejected him, but in fact, physically he did, and he had to report back. So that's an interesting question. Okay, the second question is the possession of the child porn in cache enough to constitute the crime of possessing? And in this case, the court said yes. They said, now it appears that he was not smart enough to actually get to it, but the court did say that there are experts who indicated that because it's in cache, if he was sophisticated enough and, if he tried to get to those files, Windows would send some messages saying, you really shouldn't go here, you shouldn't. But as long as he said, okay, he could get there and he could change the names and save them as his own files, and therefore he possessed them. Now, I say compare with the Kaczynski case, which is a Ninth Circuit case. In that case, a guy had 19,000 child porn images on his computer, and they said they could not be used because, in sentencing, because of advanced downloading, lack of sophistication, etc. As you know, if you use some of these browser accelerators, they'll actually download files on the page that you're on, even though you haven't asked it to download them, just so that if you click on that, it'll already be pre-downloaded. So in theory, you could have images in your cache that you never knew about, that you never even wanted. So one of the courts said that was significant. This particular court said no. It may have been the fact that he actually admitted that he did go to these sites and looked at them, so that would be kind of a significant issue. Okay, so here's another border case. Comes on the heels of the prior one. Arnold flew 24 hours from the Philippines to Los Angeles. He arrives dead tired. As he tries to go through customs, they said, well, we noticed you have a computer. Would you turn it on to show us that it works? He does so. When he turns it on, they see two files, one called Kodak Pictures and one called Kodak Memories. And for some reason, this seemed to spark interest in the border inspection agent. So she says, why do you have these files? So she started looking into them. And she found two nude women. Now, adult porn is not illegal in this country. Child porn is. But she thought perhaps there would be child porn on here. So she said she wanted to seize the computer. She seized the computer, and 2 weeks later, they did find child porn on there. He moved to suppress the evidence, saying it was an illegal search. How many think this search is illegal? How many think it's legal? Okay, about 50-50. Okay, now you would think from the last case that this would be legal under what exception? The border search exception. Okay, and that's actually how it turned out eventually. But I will say the district court tried to change it a little bit. At the district court, they said it was illegal because they said even at the border, the search cannot be overly invasive. So if you're crossing from Mexico, let's say, into California, they can search you without a warrant, but they can't say, take off all your clothes, we need to do a body cavity search. Okay? That would be going too far, even under the no warrant requirement, because it cannot be overly invasive. And what the district court said was, when you take someone's computer and just start searching through everything, because of the way people use computers now and store so much private information on there, it's basically an overly invasive search, therefore requiring a warrant. That went up on appeal to the Ninth Circuit. The Ninth Circuit said no. The Ninth Circuit said overly invasive only applies to invasions of the body, physical body, your body. So body cavity searches, making you strip down to nothing, etc. But it can never apply to property, regardless of how invasive it may be. So that's where the case law stands right now. So now this is causing a lot of people to be nervous. Some people who do work for corporations where they're carrying proprietary information, they don't want to travel across the border anymore because the government might seize that data and they're afraid that the government might do something with their proprietary data that they don't want. Some foreign countries aren't either. So there's all sorts of ways to get around it. You can just email it out encrypted because they're not border patrols in cyberspace. So there's a lot of different ways, but a lot of people are much more nervous about carrying things across the border now. And interestingly, when I came to the country recently, I was at one of these border checkpoints, and so I looked at the guy and I said, he says, do you have a computer? And I said, yes, I do. And I just kind of was waiting for him to say, he wanted to check it or something, and I wanted to see how this worked. And he says, well, are you aware of, what types of searches we do? And I said, yes, actually, I teach in this area. And I said, I'll be very interested to see how you do this. And he says, oh, no, you don't have to worry. He says, I can tell you're not a child porn, collector. And I was like, really? And he's like, oh, yeah, I can spot him a mile away. And I'm like, boy, I'd love to talk to you more, but I don't unfortunately have time. But I also didn't want to give him any reason to change his mind. But okay, this next case also is another border case, but it has a little different twist to it. This is called In re Boucher. And this individual, he's crossing the border from Canada into the United States at a place in Vermont. And when he crosses, they also ask him if he has a computer. He says yes. And then they ask him, do you have any child porn on your computer? And in a moment of amazing frankness, he says, I'm not sure. He says, I download adult porn, and sometimes child porn comes with it, and I try to delete it all, but I'm not positive if I get it all. And they said, okay, well, you're going to have to turn this on and show us then. So he turns it on, and they said, where would this possibly be? And he says, probably on my Z drive. So he enters a passphrase to get to his Z drive, because his Z drive is encrypted. They see some images on there that they think are suspicious, probably child porn, so they say, okay, we're going to have to seize this. They seize it and power it down. They take it back to the station. You already see, I can see some of you smirking already. There's problems here. Okay, when they try to do the image, they realize that they're missing the Z drive. Nothing comes through on that. So they call him back and say, we need that passphrase. Well, he had seen an attorney in the meantime, and his attorney said, no, we're not giving any passphrases. So he says, I refuse. So they say, well, we're going to force you to. We're going to take you to court. So the issue is, first of all, can he be made to give his passphrase? How many think he can? How many think he cannot? Okay, and what are you reasoning? What's your rationale for why he cannot? Right, self-incrimination, because he would be testifying, in a sense, against himself by giving that passphrase. Now, the passphrase itself does not, but by giving that passphrase, he's basically saying, this is my computer, The things behind this passphrase are mine, and therefore if there's anything there that's illegal, I basically am responsible. So they realize that at the last moment that's not going to work. So instead they say, okay, well, we're not going to make you give us the passphrase. We just want you to come to the grand jury hearing. We'll give you the computer. We won't look. You type in the passphrase and give us the computer after it's been entered. Okay, now, does he have to do that? How many think yes? Okay, and how many think no? Okay, the lower court said no. He can't be made to do that because that's also testimonial in nature. He's still basically doing an act that is testifying to the fact that these files are his. Now, that ended up getting... then the court tried to say, I mean, the government said, okay, well, what if we don't use that against him? We will tell no one that he entered that in. We will only bring in this evidence, and we will be responsible for linking these to him by some other method that we have, at our disposal. And the court said no even to that. And then they went to the foregone conclusion doctrine, which I'll get into in just a minute. That just recently got appealed. And on the appeal, the court overturned it, saying the government modified. Now the government's saying we're not going to ask for anything but an unencrypted version of your Z drive. And the court said for that you can force him to give you an unencrypted version. Now this is tricky though, because how are they going to do that? Now this is the thing. Let's suppose that they wanted you to give up your passphrase. If you had it written down on a piece of paper in your in your home, and they knew it was in a little blue book, your address book or something like that, they could serve you a subpoena saying, give us the little blue address book that has your password in it, and you would have to give it up. But if you only have it in your mind, they can't. They can't say, give us what's in your mind. Now, if they tell him he has to produce an unencrypted Z drive, what are they basically doing? They're forcing him to pull out what's in his mind. So it's still a little bit complicated in how this is going to happen. Plus, let's suppose he says, well, geez, it's been so long now, this appeal and everything else. I totally forgot the password. I mean, what are they going to do? Or what if he says, yeah, I think it's Mary Had a Little Lamb. Oh, that didn't work? Let's try 3 blind mice. Oh, that didn't work? Let's try, when are you ever going to figure out that I'm not going to give you the password? I mean, at some point, could he guess, geez, I thought it was that, 50,000 guesses later. So I'm not sure exactly how they are going to enforce this against him, but right now the case law does say he has to give them an unencrypted version. Now, I bring this case up because so many people are encrypting drives now, and technically you don't have to do anything that would encrypt you, self-incriminate yourself. But this case kind of creates a little bit of an end around that. Okay, the next case is going to be a Heckenkamp case, and I thought this might be interesting for you since you are at a state university. This also happened at a state university, the University of Wisconsin. Qualcomm, which is of course a commercial company, they found that someone was hacking into their computers, and they were able to trace it back and figure out that it was a University of Wisconsin student. So the University of Wisconsin was notified, and the FBI was notified. The University of Wisconsin system administrator started trying to track this down, and he realized that this guy was on their campus and had gotten into some files of their own as well. He'd hacked into some university files, and this made him especially nervous because it was right before finals week, and so he said, oh God, the last thing we can deal with is a hacker right now. So he blocked that individual's IP address. Well, he went home later that night, and he says, I wonder if that guy figured out a way to get around that. So from his home, he found out that someone had broken back into the university's computer system. And he tried to track it back, and it was not coming from the same IP address. But he did a lot of searching, and he found out who it was coming from, a very similar IP, just a few digits off. He remotely went into that student's computer from his home, searched around the computer, figured out it was the same guy, took some screenshots of what he found in that computer, and then blocked him and then reported to the FBI. So now the guy gets prosecuted for a Computer Fraud and Abuse Act infraction or offense, and he moves to suppress, saying that when the system administrator went from his home remotely into his student computer, that violated his expectation of privacy. How many agree? How many disagree? Okay, well, at least we're getting some healthy debate on both sides on these issues. Okay. In this particular case, the court held that a student, at least in this case, did have a reasonable expectation of privacy in his personal computer, but that nonetheless, the school, which was a state school, so was still bound by the Fourth Amendment, had a special needs exception. In other words, this system administrator was trying to protect school property, the school situation, right before finals week, etc. He wasn't operating at the behest of law enforcement. In fact, the FBI said, don't do this, you're going to mess up our case. But he did it anyway because he felt he needed to protect the school system. So the court held in that case that because of that, he fit under this narrow exception called the special needs exception, where the school was just trying to protect its own computers, and they upheld it, even though they claimed that the student in this case did have a reasonable expectation of privacy. So this is a very interesting case. The special needs exception is hardly ever invoked by the courts. In this case it was, and they have cited it in a few other cases subsequently. So now I will say though, if you look at the bottom, look what the court claimed. The court claimed besides, the system administrator did not view, delete, or modify any of the actual files in the computer. Okay, how can you search through a computer without viewing, modifying, or deleting any files? I don't know how you could do that. Okay, so obviously the court got the technology a little bit wrong, but in any event, that was their holding. Okay, now this is an interesting case because it deals with interceptions. An individual worked for Valence Media. Valence Media was the company that developed Torrent Spy, and then later he quit. But he was very concerned about what his bosses may say about him to subsequent employers. So what he decided to do is he hacked into their computer system, found out what his boss's email was, and made a copy of all of his boss's emails and had them automatically forwarded to an anonymous Gmail account that he had. So he was basically getting everything that his boss said because he wanted to make sure his boss wasn't saying anything bad about him. Well, eventually he says, gee, they're saying a lot of other interesting things, things that the Motion Picture Association of America might be interested in, because Torrent Spy obviously is a file sharing software that can share movies, which is a big concern of the MPAA. And so the MPAA said, we will pay you $15,000 for that email that you've collected. So he said, oh, no problem, here you go. So when that happened, his boss sued, saying he violated the hacking statute by intercepting my email, or actually the Federal Wiretap Act. He violated the Federal Wiretap Act by intercepting my email. So, do you think that copying and forwarding an email from a hacked account constitutes an interception under the Federal Wiretap Act? How many say yes? How many say no? Okay. Interestingly, the court said no, to everyone's surprise, including virtually everyone in the Department of Justice. Because if this isn't hacking, then we never have to get Title III court orders again. Because it's very easy to go into someone and just forward all their email. Now, the court below, what they were trying to do is they said, well, interception, the way I think of interception, it's like capturing the message en route. Like if you intercept mail, you take it out of the mail system. You know, you're intercepting the mail. She says, well, he didn't intercept it because he didn't take anything away. His boss still got his email, and it wasn't even changed. He just made an extra copy of it and forwarded it. So there's no interception. So the court below tried to say, we don't believe this is interception as we interpret that term to be defined. But, you know, it'll be interesting. The case is supposed to be heard on the 7th of October of this year in the Ninth Circuit, and I would be shocked if the Ninth Circuit does not overturn this. Because if this is upheld, then there will be, you know, a lot of police forces that will be very happy because all of a sudden they won't need to get Title IIIs anymore because they can do all sorts of interceptions and not call it interception. Okay. This has become another recent trend in the law, and this deals with the Computer Fraud and Abuse Act and bad purpose. What happened in this case was the Drug Enforcement Agency was conducting a drug investigation, and it turns out that the target was hosting some an informant outing website. In other words, the Drug Enforcement Agency has some informants that no one's supposed to know about. They keep their identity very secretive. All of a sudden, they were finding out that somehow someone was finding out about it, and they were posting it on this website saying, by the way, this guy with his picture, name, etc., is an informant. Watch out for him. And they're like, man, this is just really messing up our investigations. How is this person finding this stuff out? Well, they eventually tracked it back to an individual who had access to NCIC, which is the National Criminal Investigative Center, Crime Investigation Center. And that has all sorts of information on it, which included the identities of these undercover agents, apparently. And so what they said is, well, you should not have been able to pull that data down and provide it to these people who subsequently put it up on this website. Now, what they charged him with was unauthorized access or exceeding authorized access. Now, he did have authority to use the NCIC system. He was a person who was authorized to use that. But they're claiming that, well, the way you used it was not authorized. So the question is, does that fit within the terms of the Computer Fraud and Abuse Act? How many think it does? How many think it does not? Okay. This was also a close call, and the courts have actually split on this. But in this case, they said it does. They said that although he was authorized to access it, he wasn't authorized to access it in this way, so he exceeded his authority. Most courts seem to be going the other way. Most courts are saying, no, this was a hacker statute. And what they meant by going beyond your authorization or without authorization is that you didn't have any permission to do it. Not that you just did it for a purpose that they didn't really like. Because as soon as you start converting it to that, it really starts expanding the statute quite measurably. And so it's unclear how this will go. There was a case that just came down a couple days ago, LVRC Holdings versus Brecka, which I cite in that last bullet, where they're talking about, does disloyalty count? Because some people, when they're about to lose their job, they start sending home all the secret documents on that particular company's machines. And so some companies have sued them under this hacker statute, saying that was unauthorized use of the computer. And a lot of courts are saying, no, no, no. He was your employee. He was allowed to use your computers. You have to prosecute him under some other law. But some courts are now saying disloyal use can actually constitute a hacker offense. So we'll have to see how the courts come down on that. Now, some of you may have heard this case, the social networking case. Drew, she had a 13-year-old daughter. She apparently wanted to somehow help her daughter in some kind of a strange way. So she posed as a 16-year-old boy on MySpace. And then she befriended one of her daughter's friends and set up this whole fake romance. And then she basically told her daughter's friend, basically, it's over, you're not even worth it, blah, 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 and had this really messy breakup, which subsequently resulted in the other girl committing suicide. So this became a very big case, of course. They brought it to the Missouri U.S. Attorney, and he says, I won't prosecute this. This does not fit under any of the federal statutes that I have available to me. Okay, it's unfortunate, it's terrible, but there aren't statutes to cover this. So they brought it to the Los Angeles U.S. Attorney, because MySpace is located in Los Angeles, and they try to get jurisdiction there, and he said, I will bring it. So the question is, do Drew's actions amount to unauthorized access to a protected computer? Now, protected computer under U.S. law is defined as any computer attached to the internet. So when she signed up for MySpace as a 16-year-old boy, but with MySpace's approval and everything else, of course they didn't know she was a woman, an older woman. Does that constitute the hacker violation of unauthorized access to a protected computer? How many think yes? How many think no? Okay, you're all wrong then, because the court actually held that she was. Now that's very strange, because what this basically means, the government's case was MySpace has specific terms of service that you have to sign as part of your contract. And those terms of service say that you won't lie. Okay, we all know that no one lies when they sign up for a MySpace account or does anything else on the internet. Okay, so remember that. But anyway, they eventually said because she lied on that terms of service, she broke that contract, and if she broke the contract, then her access was not authorized because she was not complying with the access. And if her access was not authorized, then she's committed a federal crime. Now, a lot of people didn't like that because they said, wow, a lot of people don't even read those contracts. They just click the end. Yep, whatever. Okay. And so they said, boy, you've just made criminals out of a whole lot of people, because a lot of people also lied. They give fake names, Mickey Mouse, whatever else. And so, what does this mean? So interestingly, on the 28th of August, just recently, a judge, she made a motion to dismiss, claiming that the government could not have proved their case, that there were problems with how they charged this, and the judge actually dismissed it. This is not an appeal. The judge, just in retrospect, is saying that even though a jury acquitted her, even though a jury convicted her, as the judge, he's overruling the jury, which is a possibility. You're allowed to do that as long as the law does not support the jury's findings. And he's saying that violation of the terms of service alone cannot transform that into a federal crime. And I think a lot of people are actually more comfortable with that. But it'll be interesting to see where this case continues to go. Okay. This is kind of an interesting case. It just shows how we're going with the law and everything else. Oh, actually, we're getting kind of close on time. So this just basically says if you do that automatic sign up for Facebook and you say, yeah, go ahead, go through my book. If it accidentally sends someone a friend message that has a restraining order against you, you just violated the restraining order. Because you contacted that person, even though you didn't intend to, perhaps. Okay, these are two kind of interesting cases. A Japanese woman killed in the online world MapleStory, which is kind of like Second Life. It's just a different version. Her husband, after he gave her a messy divorce, can she be charged with a crime? How many think yes? How many think no? She actually will be. She'll be charged for hacking into his account. That's how she was able to kill him. She hacked into his account. It was a violation there. Obviously, you can't be charged with killing him there. Two Dutch teens tried to coerce the third teen at knife point to get his virtual amulet. It's a really hard to get amulet. They forced him at knife point to give it to him. Obviously, that's a crime, forcing at knife point. But the question was, can he be charged with theft of goods when they did that? Is an amulet, a virtual amulet, a good? How many think it is? How many think it is not? Okay, the court held it is. The court held, even though technically it doesn't exist, it has value, and so therefore it's a good. So, okay, and that's really all I have time for. I do have these slides available if any of you want them. I do have a few more things that I wasn't able to get through. Basically, just to wrap up real quickly, I just wanted to show you that the law is still developing. It's a little all over the place. There's still a lot of splits in the circuit, but there is starting to develop some maturity, and I tried to show you some of those trends. Thank you very much. You've been a very good audience. Yeah.
What do you think about all of the music copying, movie copying, things like that? How do you think that falls under law?
Well, in most cases, it depends on the copyright status of the music. So there's some music and there's some literature. I mean, obviously Shakespeare's works, they're no longer copyrighted. So if you're just copying things like that, there's no problem. If you're copying things that still are copyrighted and you're not paying for them, that could be a problem. But as far as music goes, there's another little wrinkle. There was actually a senator who thought he should be able to copy music, to make one, version for his car and one version for the beach house and all this other stuff. And he says, "You mean I can't do that?" And he goes, "Well, I'm going to change the law." So he wrote a law that basically says you can do it for private, non-commercial uses. Now, the way he got this by the record companies, because they were vehemently opposed to it, is that there's a fee set into certain types of things. Like if you buy a CD recorder or certain other types of devices that can do this, there's a fee automatically, you don't see it, that gets included in that goes into a central pot. And at the end of each year, Madonna can say, "I want my share," and they give her, whatever percentage share she has of all the music sales, she gets that percentage. And so you're allowed to make private, non-commercial copies. Now, some people have said, "Well, what does that mean?" I mean, I used to teach at a college, and our college students said, "Well, I'm giving private, non-commercial copies to everyone at the university." They didn't really envision it that way. It was more like family and personal uses and things like that. But it hasn't been really litigated in the courts. And then some people said, "Well, if you can do that for music, I'm going to make some private, non-commercial copies of my videos, that I can rent from Blockbuster and a few other things." Well, see, the law didn't extend to that. So that's really a different area. So it becomes very kind of messy. And a lot of these file sharing things, of course, if you're referring specifically to that, most of them are going to involve all sorts of illegal sharing and purchasing that isn't being done. Any other questions? Yeah. Yeah, there are some jurisdictions. I don't think it was done at the federal level, but a lot of states did enact some cyberbullying statutes that are kind of like traditional bullying statutes. It's tricky, though, because you have to show that they're doing certain things over the internet that meet certain criteria. And some people weren't sure, how do you define that? So the state laws vary, but yes, there are some. Good point. Any other questions? Okay, if you would like a copy of my slide, just let me know, or give me a card or something like that, or I'll give you my card, and then we can make it. And alternatively, we can make it available through CERIAS. Yeah. Okay, great. Thank you very much.